So Bruce, you wrote in the Epoch Times just recently, December 18th, about peak insanity. And the example you used was the University of Toronto Law Department, where they talked about, they wanted to bring up an Indigenous case, a real life Indigenous case of alcoholic parents giving their kids over to a non-Aboriginal couple, a CAS, and the couple eventually wanted to adopt the kids, but then the father came back, said, I've got the alcohol problem licked, I'd like my kids back. And the Law Society, or not the Law Society, the department wanted to use that as a real life case to instruct students, but some students objected. Can you explain?
Yeah, so this was a report in the Globe and Mail. So the details we have to take from the report, but I gather that this was an assignment in their first year legal research and writing class. So it sounds like it wasn't actually a course on Aboriginal law, it was a course on how to solve legal problems. So it could have been anything. But in this case, they chose this kind of a case so as to ask the students to analyze those facts in light of an Ontario law that directed questions of children's custody and adoption and so on in a certain way. And they took the facts for the problem directly from a real case, as you say. And not only were they taken from a real case, but that real case also reflects a thing that happens quite frequently in the child welfare area, which is Aboriginal children who have parents who run into difficulty with substance abuse. And then the Children's Aid Society takes a role and puts them into foster care, and in this case, the non-Aboriginal family, apparently, in the problem, who had looked after the children for a couple of years, volunteered to adopt them. Mm-hmm. So there you have a fact scenario. And it's a real fact scenario and also based upon a frequent circumstance in the real world. And yet, according to the report, some students were offended by the question, so they complained.
The nature of their offense?
Well, I don't know exactly what, but the implication is they were offended by the use of an Aboriginal stereotype. That's certainly what the dean referred to when he apologized to the students. Instead of saying to the students, look, this is a real life. This actually happens. It's based upon a real case. Deal with it, because that's what you're going to be asked to deal with as lawyers, real problems. The stereotype, so the word stereotype is a strange word, right? Because the implication is it's based upon an idea of a certain group of people that is unfairly imposed. That's not really the case in this situation. The stereotype, if you want to use that word, is based upon something that actually happens. It happens a lot. Aboriginal children are overrepresented in the child welfare system. This kind of case happens frequently. And so the apology is peculiar. You're apologizing for what?
So it's not just the offense these students took, which I found to be a little peculiar.
Yeah.
How could they be offended at the facts?
Right.
It's the apology that really gets you.
Yes, well, you can understand, I suppose, in a way. I mean, these are first-year law students, and so they're trying to find their way, and something they find unpalatable. I mean, complaining to the dean about a problem is not something that I or my classmates would have ever thought to do in our era of going to law school. But nevertheless, if you want to give them the benefit of the doubt, students complained. The real strange thing that happened was the apology from the administration.
Yeah.
That's just bizarre. I find that very strange. That a law school administration would take it upon itself to apologize for the selection made by the teacher of a course for an assignment that was derived from an actual case. That's very strange. And I don't really know what they would have expected the teacher to do if they were going to choose a problem in that area of the law. So if you don't want real facts, do you want fake facts? Do you want to make up a scenario that is uses a different kind of stereotype that might not actually be quite in accordance with the trends that you see in the real world. It's a head scratcher.
It gives one pause, because you think of some of the cases where the judges have come down. The layperson would look at it and going, "That's not right. Your case law is being made that doesn't seem to conform to the common sense, at least. It may conform sometimes to the law, but not to common sense." And then you start to think that, I think as you pointed out in your article, judges come from lawyers, lawyers come from law schools.
Well, let's just talk about law schools just for a minute, because I don't know what the general public thinks happens there. But more and more today, law schools are what I would call social justice institutions. There's a difference between teaching about the Western system of justice and teaching about social justice. Those two things are quite different.
Usually, in my estimation, when you put a modifier in front of a word, it almost negates the word. Social justice means no justice. If you meant justice, you'd say justice.
Well, perhaps that's one way of looking at it. I mean, some might make the case that social justice is not justice at all, and I would be inclined to maybe agree with that. One of the main differences between the two ideas is that the Western idea of justice is based upon the individual. So you're responsible for what you do, and responsible for only what you do. So your actions are within your own hands, and we don't punish people for the actions of their second cousins once removed, or their grandmothers, or their neighbors. If you do it, you are responsible. If you don't do it, then it's got nothing to do with you. Social justice, on the other hand, is based upon the idea of groups. Group responsibility, group victimhood, trying to manage and manipulate society so as to make up for the groups of victims and oppressors. And so if you're in an institution that thinks like that, then it's not enough simply to present facts, because facts themselves, I suppose, represent a kind of oppression. And you have to massage them so that that oppression doesn't reproduce itself. It's a strange set of propositions. And if you take them apart, I don't think they hold together. But nevertheless, you have to go there in order to figure out why what is happening. If you try to do it on the basis of the, within the school of thought, which is the Western principles of justice as we understand them, they won't make any sense, which is one reason why this doesn't make any sense. If you're thinking in a straightforward way, I would say the idea of presenting a real case with real facts, represent a real trend, and asking students to solve the problem is not problematic in any way. In a school of social justice, there's a lot of problems with it, for the very reason that it's true.
The basis, I guess, of the offense, an offense is what? It's a feeling. And you have these first-year students coming up saying, "My feelings are hurt by your facts." What does that say about the level or the quality of the student these days?
My perception is that kids now who are in public school are exposed to teaching which suggests that feelings are the most important thing. Now, I don't spend my time in public school classrooms, but I gather the social justice imperative is even stronger in those environments than it is at universities and law schools. And it seems to be the case that university-age people these days consider feelings to be extraordinarily important. In the article, I talk about an experience that I had when I was the associate dean many years ago at the law school at Queen's, where a group of students came to me to complain about their course in negotiation.
That's in the article.
In the article, yes. And their complaint was that their teacher was telling them that their first responsibility as a lawyer to one of the parties involved in the negotiation was to look out for that party's best interests.
Makes sense.
It makes a lot of sense, and in fact, that is absolutely correct. If you don't do that, then you are not fulfilling your role as counsel for that party. But the students found that offensive.
They found it adversarial.
They found it adversarial.
That's the basis of our system.
Yes, but I think they had the idea in their head that adversarial characteristic was a bad thing, and that negotiation should be used as a way to get around that bad thing, instead of recognizing that the essence of the negotiation is in fact that thing itself. Negotiation is adversarial. Now, if you can find common ground and find a solution that works for everybody, well then great. That's hopefully the outcome of negotiation, but that doesn't mean you're not adversarial. And it doesn't mean that your role as a lawyer changes from representing your client to trying to find a common good that exists only in the imagination of various people. So anyway, the point of the story was that they had an emotional reaction to and maybe also intellectual reaction to the lesson that they were being delivered, didn't like that lesson, came to me to complain, and I had to tell them that their teacher knew better than they did about what their responsibilities were, and that they should ignore their feelings and go back to class.
I wouldn't imagine that you'd still be doing what you're doing if you didn't find that there's some hope and that we have yet to reach peak insanity. Do you find that there's hope? Do you find there's some students out there who actually see
yes.
it?
Oh, no, absolutely. Listen, this is by no means a universal thing. There are lots of students in law school who well, there are students in law school who think in various kinds of ways, which is the way it's supposed to be. There is not a universal philosophy. Not everybody is sold on social justice thinking. Not everybody is guided by their feelings or their knee-jerk reactions. So there are good students in law schools. And there are good teachers in law schools. There are good professors, lots of good professors. Not everybody is sold on this, but on balance, both institutionally and in terms of the faculty that are at law schools today, the vast majority of them are inclined to the social justice point of view. And without having sat through other people's classes at length, my best guess is that a certain kind of message is being delivered inside the law schools, which is very much in line with social justice thinking. And so when law students graduate, they have that particular idea in their head. They carry that through in their careers as lawyers, and as we say, those people sometimes become judges or legislators. And so that philosophy becomes spread through the legal system. And when we look now at the system that we have, and I have frequent occasion to think, we're kind of losing our way. This is not a good idea in this respect or that respect. I think in large part we can trace those problems back to the kinds of lessons that are coming from legal academia.
Great. Thank you for your time, Bruce.
My pleasure. Thank you.